cases left on the docket, and the first one we'll take is MALBEC Investments versus People's Bank. How much time rebuttal you want?
5 minutes is fine, Your Honor.
All right.
Thank you, Your Honors. Robert Swift, representing the appellant MALBEC. Would the court like a recitation of the underlying facts?
You don't need.
Well, let me ask you about the facts.
Sure.
Because I was, I actually took the time to read all the briefs in the case last night. I went back over them, and I didn't even see a statement of the facts in either brief.
All right, well...
You had a statement of the case and a summary of the argument, and it was a most unusual situation because I was trying to get a handle on the facts, and the rule says there's supposed to be a statement of the facts with citation of the record. I mean, how do you get around that?
Well, I apologize for that, Your Honor, if that wasn't clear. This is a personal jurisdiction issue where the only facts at issue are the underlying complaint that we pled, and the plaintiff is relying on certain affidavits that they filed in opposition to personal jurisdiction.
So you're saying that the facts are what's stated in the amended complaint.
Correct.
And also we have to take into consideration the essentially unrebutted affidavits that attest to their contacts with the state of Florida.
Right, to the extent the court believes that they're relevant, we don't believe that the affidavits really have any bearing on the narrow issue that was decided.
Well, let me ask you this then. Is it your position that all you have to do to cause somebody to defend themselves in the courts of Florida is to allege a conspiracy and allege that they're one of the co-conspirators and allege that one of the co-conspirators is a resident or has had sufficient contacts with Florida?
Well, by and large, with the reservation as spelled out in the NHB advisors case, which we relied on, which essentially says you have to, quote-unquote, successfully allege a conspiracy, and in that regard, the cases in Florida and otherwise say that what you need to do is plead specific facts as to the conspiracy to put them on notice of how they're involved in it. This court did not address at all, although I think it was argued, the sufficiency of the facts as pled with respect to the conspiracy. The court simply ordered that the issue was that we failed to plead specific facts as to minimum contacts, and we believe that that was improper based upon the pleadings. We believe that there's sufficient allegations with respect to both People's Bank and Mr. Moser as to where their involvement was in this chain of events. We do believe we specifically pled what the conspiracy was. The nature of a conspiracy, of course, is that you can only get so specific because you're not going to be able to get people to stand up and say, hey, this is what I did.
Let's talk about the tort first, okay? Is this the kind of conspiracy that was the subject of the Highlight case, or is this the other kind of conspiracy, which is that they agreed to commit some other tort?
Believe that it was essentially an agreement to commit torts in Florida.
And name the torts.
Well, there's...
Because conspiracy isn't...
Sure.
You agree that unless it falls under the Dana Highlight case, which was... You remember that case? That was the case where they, all the Highlight Frontons got together and said they weren't going to hire this particular highlight player. And they said, well, that is the tort of conspiracy. All these other conspiracy cases are an agreement between two people to commit some other tort, right? You agree with me about that?
Yes, and neither one of us really spoke to the Highlight case, but I have read it. And
It's the latter form of conspiracy.
I believe it is, or at the very least, Your Honor, and I hate to say it because I really didn't think about it in advance, but it may be kind of a hybrid of the two. And I say that because...
I don't think there is such a thing under Florida law. I mean, as I understand the law, you either got one conspiracy, which is an intrinsic conspiracy, and then you've got an agreement to commit a tort. There's no such thing as a conspiracy to breach a contract. It's got to be a tort, so...
I agree with that.
Assuming that I'm right, name your tort.
Well, there's violation of the Fraudulent Transfer Act, Uniform Fraudulent Transfer Act. There's a tort of civil theft. There's a tort of conversion. Those are the torts that we believe were involved in this, and we believe that, again, understanding that the court is familiar with, well, the facts as pled, at least in the complaint.
Conversion may be the only tort that you named. I think the other are statutory causes of action, but, so you got the tort of conversion. So what is it that you alleged with specificity that Peoples did,
So we believe that...
constituted the tort of conversion?
All right, and so, under Florida law, we believe it's clear that when you join a conspiracy, even if the act was committed prior to your involvement, you become responsible for...
I'm with you on that.
All right, so the issue here is Peoples enters into this participation agreement with Marshall, we believe knowing that the money that, and the fees that they're going to generate off of this agreement are illegal because of the fact that the monies, everybody knew, Marshall knew, we believe Peoples and Dan Moser knew, that Lake Austin Properties did not have money to pledge as collateral to get this $140 million loan. And what they did was they took $30 million of investors' money.
You're arguing facts. We need to know a little bit about jurisdiction.
All right, and so from a personal jurisdiction standpoint and trying...
With those facts in the brief, but at any rate, if you could just put us to jurisdiction.
Paragraph 64 of the underlying complaint specifically indicates that let me start with paragraph 32. Paragraph 32 alleges that Dan Moser, who is a high-ranking executive for People's Bank, was essentially put in charge of dealing with the participation agreement. It's undisputed that Marshall and Eric Johnson, who's already answered the complaint, were active in Florida in handling this. Paragraph 64 of the underlying complaint specifically indicates that Mr. Moser was aware of facts and failed to disclose to Sentinel, who bought out People's interest, all of these facts that it would need to know. Otherwise, Peoples would still be holding the paper. We believe that's sufficient to allege that they were part of this conspiracy. Furthermore, paragraph 85 of the complaint indicates that Moser, who is again a high-ranking official of People's Bank, was aware of the improper diversion of the funds that were supposed to be used to build Avalon and Magnolia investors' funds, and they were illegally diverted to as collateral for a $140 million loan to build Grand Palisades that never got built. So those are the facts that we believe are sufficient to put Mr. Moser and People's Bank on notice of how we believe they were involved. And I think that, when you look at the cases that talk about, long-arm jurisdiction and minimum contacts, essentially NHB Advisors says when you successfully allege a conspiracy, you take really the analysis out of the minimum contacts. As long as there's long-arm jurisdiction, you place all these people in the same position as if, they had committed the tort and where that tort occurred. And the tort clearly occurred in Florida. We have a Florida property, Florida investors, and the money was diverted from Marshall and Eric Johnson and those people. They took money in Florida. And so we believe it's clear. And I think that, the lower court simply said you didn't plead sufficient minimum contacts. I don't believe that's the case. The court really didn't address the conspiracy issue, and that was briefed by the appellee in the case that this court should affirm, because even if, for some reason the court was incorrect on that we didn't plead specifically as more specificity as to the conspiracy. And I would suggest that, and I think we argued this during the hearing on the motion to dismiss, that if that was the case, then we would have been entitled to amend the complaint again. And in fact, the complaint has been amended again as to other defendants that are ongoing. An affidavit has been filed in the underlying case. Again, that's not necessarily part of this record, but it just is, to me, informative to the court that the court took a step that shouldn't have taken. At the very least, the court should have said, I need more information on how this conspiracy took place in order to...
Ask for leave to amend?
I believe during the hearing, Your Honor, on the motion to dismiss, we told the court that we could amend the complaint. We also told the court, although we didn't brief this issue, that we could conduct jurisdictional discovery as needed to find out more information.
You've got to ask for it, though. I mean...
I understand.
They got this motion teed up. I mean, you're going to file some kind of motion asking for jurisdictional discovery.
Absolutely, and in all fairness...
You didn't do that?
No,
You just
absolutely
suggested
not.
it at the hearing.
No, we stood on our pleading. We believe it was appropriate, and we believe there were sufficient facts. Again, under the auspices of what we're dealing with in this case, we pled, at least at that time, what we knew about Peoples and Mr. Moser's involvement in the case. Again, we believe sufficiently, and had the court suggested in some way at that hearing that I'm going to rule that you have not successfully pled a conspiracy, and therefore I'm going to dismiss, at that point, we would have asked for leave to amend, but that's not what the court ruled. I don't have really...
Did you file any counter affidavits to the affidavits that were filed?
We did not, Your Honor. Our position was, and I think it was briefed, that we did not believe that the affidavits spoke at all to the conspiracy nature of our allegations and spoke more to the minimum context, which, again, we were relying on the tort being committed in Florida by others who were part of the conspiracy. I really don't have any additional argument unless there's questions.
Over 8 minutes for rebuttal time, sir.
Thank you, Your Honor.
Good morning, Your Honors. My name is Adam Herman, and I represent the appellees, People's Bank and Dan Mosier. As far as the facts of the case, I do apologize. I thought, and as I sit here today, I believe that I put the statement of the case, or I did record citations for the court so they could go back to
You
the
put a
record.
statement of the case in there. That's different than a statement of the facts.
Absolutely.
Some people combine them, but you all, neither one of you did.
I thought I put the record citations, but if I didn't...
You might have. I was talking to him before.
Okay.
You might have put some record citations in there, yeah. Yeah,
Okay.
I didn't see any coming from the appellant.
That said,
Let me ask you this. Where's People's Bank located?
Indianapolis.
Indianapolis, okay. Do you agree with counsel's assertion that if a conspiracy is sufficiently alleged, that as long as there's jurisdiction over one of the co-conspirators, then there is jurisdiction over all of the co-conspirators?
No. Absolutely no. And
What authority do you hang your hat on that?
the allegations, or the argument that's being made is that, the co-conspirator theory somehow negates the 14th Amendment to the United States Constitution and international shoe, that one doesn't have to look at minimum contacts with that co-conspirator who has a relationship with the person who has contacts with Florida. And there is really no cases to suggest that. I know counsel hangs their hat on NHB to say that that's what that case says, but when we dive into that case actually did not say that. That case was focusing on the long-arm statute. There's a very brief blurb at the very end where the court says, we also see due process. They don't do an analysis. It's a very inarticulate, I apologize, inarticulate writing, but the court does look to an affidavit that was submitted by CISIC, and CISIC was the appellee in that case, where they found jurisdiction, and didn't find jurisdiction, and they find that in his affidavit, he says that he was in Fort Lauderdale, meeting with the CEO briefly, right around the time that the plaintiff alleges there was a conspiracy, and that he received an email from the CEO of Butler stating about whether or not his company could buy out the Butler Company. So the court found, it's my belief from reading that case, the court found that, yes, the long-arm statute was satisfied by the co-conspirator, but we also find due process satisfaction in the affidavit, that there is minimum context, systematic and continuous, or it doesn't violate traditional notions of fair play and substantial justice. The very premise of this is, and Venetian, the Florida Supreme Court in Venetian said it the best, it's a two-part analysis. We have whether the plaintiff pleads under the long-arm statute facts sufficient, and if in fact that is satisfied, then if the defendant so chooses and challenges the personal jurisdiction on minimum contacts, international shoe, and all the cases we learned in law school.
Well, are you hanging your hat, which part of the Venetian salami analysis are you relying on?
The minimum contacts, the 14th
You're
Amendment.
arguing a constitutional issue here.
Yes, yes, Your Honor. I'm not alleging, I mean, there is an argument that it wasn't pled specificity, and it's addressed in the brief, but I think the more important analysis first is the actual minimum contacts for constitutional purposes. And
Well, you're not suggesting that it has to be a physical presence in the state, are you, to meet the minimum contacts test?
no,
You could commit a tort and be complete, stay in Georgia the whole time you're committing a tort if it affects a victim in Florida, right?
yes, there is case law, and that's, you can make telephone calls, and I think, in fact, I think it was Burger King that was the issue with regards to phone calls, or, no, I'm not suggesting that at all. What I'm suggesting is that we look to the second prong of the jurisdictional test, and the second prong in Venetian says that the defendant, if they challenge, comes forth with an affidavit. Then the burden shifts to the plaintiff.
Yeah, but that's they only have to rebut factual matters that are in the affidavits of the defendant, right?
Yes.
And there's there's no dispute that everything that your clients said in their affidavit is true, so there wouldn't be any reason for them to file an affidavit, right?
Except for the point that the affidavit from People's Bank attaches to participation agreement. And that participation agreement basically disputes the conspiracy. Because for one to have a conspiracy, we have to have an agreement. Well, if we look at the participation agreement that was attached as Exhibit A to People's Bank's affidavit, it sets forth the chronology of how this loan occurred. You have this Grand Palisades, this development, and plaintiff's own allegations are it wanted a loan from Marshall. Marshall wouldn't give it a loan unless it showed some equity. So it took $30 million from two other developments of owner's money and was transferred over. At that point, Marshall goes ahead and makes the loan. Once they make the loan, they then go ahead and offer up participation agreements to various banks. This particular participation agreement with People's calls for, I believe, a 3% participation agreement. The Exhibit B to the participation agreement...
Funded the loan at that point to some extent.
I'm sorry?
People's provided People's basically bought a piece of the loan, right?
Right. They took a piece of the loan, they tried to spread it out, much like an insurance company spreads the risk. They spread out the interest in the loan, not the property. So now you have a sequence of events. You have the alleged fraudulent act.
What you're saying to me is that because you attached the participation agreement to the affidavit, that it would have been incumbent upon them to file a counter affidavit saying it didn't happen like that.
Yeah, it didn't happen like that, or we have this information, or we heard this conversation, some type of affidavit where the trial court then turns around and says, I can harmonize these affidavits and decide whether or not there's jurisdiction, or we're going to need to have an evidentiary hearing. But what the courts do say, and I think if you would, it is, I want to get the citations correct for the court, Hilltop Holdings Corporation, they basically say that if you do not file an affidavit, if the defense comes forward with an affidavit and the plaintiff does not rebut, then under Hilltop's holding, the court is required to dismiss. So, and I believe that's a second DCA case.
How do you respond to counsel's argument that at a minimum, since the court was relying on the insufficiency of the facts in the complaint, that upon request, he should have been permitted to amend to add additional facts?
Because, again, the appellant is focusing on the first part of the two-pronged test. Yes, if he failed to plead with specificity, and this was a case about whether or not he failed to plead facts to grant jurisdiction under the long-arm statute, then he would have a right to go ahead and replead. But that's not what the trial court's order says. The trial court's order specifically says that she finds no minimum contacts. So she's operating under the United States Constitution and under that second prong of the test where...
Well, had they been permitted to amend, could they have pled minimum contact?
No, because even on pleading minimum contacts, you jump to the affidavit portion of it. So they could still satisfy long-arm jurisdiction. It could have been satisfied in this case.
Without an amendment?
Without amendment. I'm saying it could have. I'm not saying it did, but it could have, and
They filed an affidavit.
Right, but my argument, once I file the affidavit, it's incumbent upon the opposition to file an affidavit negating those lack of minimum contacts.
Have they been permitted to amend their pleading? There's no way that could have corrected the deficiency?
No, Your Honor, no, because they're independent tests almost. The first prong is, okay, they plead enough for minimum contacts under the long-arm statute, not minimum contacts. They plead allegations sufficient to put themselves under the long-arm statute. But satisfaction of the long-arm statute is not satisfaction of minimum contacts, and that's what Venetian holds.
Well, they got to plead facts to establish minimum contacts also, right?
I'm sorry, Your Honor?
You got, under Venetian salami, the plaintiff has to plead facts to bring them within the long-arm statute, and they can also plead the facts that bring them within the Constitution, can't they, in the complaint?
Yes and no. Yes, in that they could plead it, but when the defendant comes forth with an affidavit,
If it refutes it, if it pierces the allegation,
pieces those allegations, right?
then they have to back it up with a counter affidavit, right?
Yeah, absolutely, yes. Yes.
If they didn't have the allegata to begin with, if they didn't have the allegation in the complaint, then they really didn't get an opportunity to back it up with an affidavit, right?
Well, no,
It was devoid of a factual basis for minimum contacts.
I think they're mutually exclusive in the sense that,
You say they don't have to plead it at all. All they have to do is plead compliance with the long-arm statute, is what you say.
well, I'm saying to satisfy the long-arm statute, all they have to do is plead compliance with the long-arm statute, and that would be sufficient for jurisdiction under 48. That doesn't necessarily mean that they've satisfied minimum contacts under the United States Constitution.
They come forth with an affidavit that submits the minimum contact aspect of your argument, but it had not been pled. Would you have objected to the admission of that because it hadn't been pled?
No, Your Honor. What I would object to, though, is today, as we sit here today, the co-conspirator theory was never argued before the lower court. And the co-conspirator theory, to my knowledge, was never argued in the original appellate. The first time it's argued is in the appellate brief. So they're arguing an issue about this co-conspirator theory on the NHB that wasn't argued in the lower court. The lower court's argument was always, well, the property's in Florida, so therefore they have contacts. Now, there are allegations in the complaint about conspiracy, but the actual, what we're hearing today, what we're seeing in the initial appellate briefs, that argument is not in the lower court.
We have a transcript of that hearing in the record.
Yes, you do. And I went through the transcripts, and, I mean, you have the mention of conspiracy, because conspiracy is a count.
They don't present the legal argument that, and that authority, the NFB case, they don't present.
No, NHB is never mentioned.
NHB, I mean, yes.
Yeah, NHB is never mentioned in the lower court argument. When I first see it, we see it in the appellate court, which is, I'm fine to address it, but the court should know that it's being raised for the first time on appeal.
So what should we do with that?
Well, usually you cannot, the appellate court cannot consider an argument that's raised first when it's not raised in the trial court.
You asked us to do that in your brief?
I did not, Your Honor, because my answer brief at the time was, they were arguing it No, I didn't, to be honest with you, no.
So you're saying they raised it for the first time in their reply, or did they raise it?
They raised it for the first time in their original brief, their initial brief, that we answered, obviously, to the,
First time you've objected to that is now?
yes, Your Honor. I don't believe it's in our answer brief. I went back and checked, and I don't think I saw it in there.
The last waiver loses.
I'm sorry?
The last waiver loses.
The last waiver loses.
They waived the argument, but you waived the counter-argument, right?
I don't know if that's actually the case.
There's no law to that effect, so don't...
I'm sorry?
There's no law to that effect.
Thank you.
Murphy's Law.
So, this is what we have. Now, with Your Honor, just so I can, maybe touch upon it. If we accept plaintiff's argument regarding the co-conspiracy theory and NHB and what they're saying, and I think Your Honor touched on it a bit earlier, was that by accepting that, they're saying that as long as you allege you're a conspirator, or you're a conspirator, and they have some contact with somebody who committed a tort in Florida, whether there's a conspiracy or not, that somehow they now have minimum contacts.
They have to plead what the nature of the conspiracy is with certain specificity, correct?
On the NHB, they're supposed to, and what...
Happen here?
No, and that, I can jump to that as well, but I just wanted to emphasize that the reasoning is flawed only in that you now could basically give a blanket assertion to anybody could bring somebody else in by saying they're a conspirator, and it's pleading some facts.
But they asked to amend.
Right. But what I'm saying is, you could go ahead and do that, and it basically negates the minimum contacts. Now, Your Honor brought up a point about specificity. The first part of the prong of the Venetian test. We're getting away from minimum contacts, we're now moving to the long-arm statute. It is true that NHB says, if you plead co-conspirator with specific facts, not conclusions. And by looking at this, and specifically the allegations, I've gone through the allegations myself.
Florida allows for liberal amendment of pleadings, doesn't it?
Right, but the court in NHB, and to a certain extent, I guess the Florida Rules of Civil Procedure would say, you have to plead with specificity. And here, there are no allegations of specificity. There are general conclusions of law. Dan Mosier knew. People's Bank knew. They were conspirators. There's no meat and potatoes. There's no ultimate facts throughout all allegations. I can go through all 60 or 70 allegations, and I can point the ones out that are applicable to Dan Mosier and People's Bank, and there's nothing that says, how are they co-conspirators? What did they do? Did they sit down in a meeting on this date in this hotel room and say, we're not going to do this until you transfer the money? There's just nothing there. It's just a matter of they knew, they had intent. And that's not what NHB considers when it said specific facts. But if I can stress to the court, I do not believe that the court even needs to consider the specificity of the allegations, because once the affidavits were filed with the participation agreement and that sequence, it was incumbent upon the defense to go ahead and put forth an affidavit disputing the conspiracy allegations, or show conspiracy, and absent that, under the second DCA, the case of Hilltop, once they didn't do it, the case should have been dismissed with prejudice, and that's exactly what occurred here with the trial court's order. I have no further argument. If the justices have any other questions, I'd be happy to entertain them.
Thank you for your argument, sir.
Thank you, sir.
All right, you got a little over 8 minutes, sir.
Thank you. I think that we have a fundamental disagreement as to what the law is regarding personal jurisdiction in Florida. And when I read the briefs and the opposition, I believe the same thing. The argument is that because of international shoe and Venetian salami and the traditional notions of fair play, that somehow if somebody conspires to defraud people in Florida of their money, that you can say, I never knew that I'd be hauled into a Florida court when I did this.
I don't think he said that. He didn't say, I don't think that's what he said. He was arguing constitutionally on the second prong and...
Sure. And I'm getting to that, Your Honor. What I'm getting to is that the first statement, the question was asked, do you agree that if one co-conspirator is subject to personal jurisdiction at all? And the answer to the question was no, and that's wrong. NHB
That
advisors...
is wrong, but what about his statement that under Venetian salami, the plaintiff only need plead facts to bring themselves within the long-arm statute? You don't have to plead the facts that bring you within the minimum contacts, right?
Well, to the extent that that was the agreement of counsel, then obviously that helps me, because...
Well, I'm not sure it helps you in that I was focused before a little bit on I was sympathetic to your request to amend your pleading. He basically is saying that the pleading was fine, but their affidavits addressed the constitutional issue, and that there wasn't anything coming back the other way on the constitutional issue, and there wasn't anything in the complaint about that.
Well, and I think that that's addressed through simply looking at NHB advisors and finding that it is not inconsistent with Venetian salami, because the reality is that NHB advisors has said, it did not say we're addressing this under the long-arm jurisdiction only. What it said, and it relied on Wilcox versus Stout, a second DCA case from '94, and a Southern District of Florida from 2010, Alandia. What it said is that if you successfully allege that any member of conspiracy committed a tortious act in Florida in furtherance of the conspiracy, then all the conspirators are subject to the jurisdiction of Florida.
Question.
Sure.
Sequentially, when did you ask for leave to amend? And did you assert, or is it of record, that you would have asserted facts sufficient to comply with what you just read?
I indicated to the court during the hearing on the motion to dismiss that if the court felt that the pleading was still deficient, that we would amend. I didn't.
What did the court say?
The court said there was argument against, and the court believed that we had the opportunity and it could rule because of the affidavits.
Did you indicate that you would allege something? Did you indicate to the court what it is that, in addition, that you would allege that would be new?
I did not. Because the reality is, and again, I think that the argument here, to me, the entire idea of the minimum...
You asked for leave to amend, but you didn't assert what it was you wanted to amend.
Correct.
The court said, no, there's an affidavit before me, there's no responding affidavit, and you ruled.
I don't know if those were the exact words, Your Honor, but I believe that that was the sequence of events, correct. But I think, again, the order was you haven't satisfied minimum contacts. That's what we're here on. And the notion, again, if someone, the allegations are taken as true. The allegations have facts in them as to how Moser and People's Bank were involved in a conspiracy.
Counsel has said that your pleading was conclusory, that you didn't allege facts.
Well, I think I pointed out to the court one fact that...
You read a couple paragraphs, but they did sound relatively conclusory.
Well, I think that when you specifically say that when, after taking the money and being aware that the money was illegally diverted, and then you pass this on to another participant...
Is that what the allegation said?
Yeah, without disclosing all the material facts, I think that that's sufficient. When you're dealing with a conspiracy, no one's going to stand up and say, this is what we did. You need to drill down into...
Maybe no one's going to stand up and say that's what we did, but you have to allege sufficient facts or have certain factors that you can point to in your pleadings that would allow a fact finder to conclude that that's what transpired.
I agree, and I believe we did, and that's why I said at the beginning of the rebuttal argument that I think we have a couple of fundamental disagreements. And number one, we believe that there's sufficient facts under a conspiracy theory. The ultimate facts in the civil rules of procedure, I understand the law there. When you're dealing with a conspiracy, it's very difficult, and I think the cases bear this out, to drill down as far as you would like to. This isn't an auto wreck or a slip and fall or something like that. You can only get so far through any type of cooperation you can get or investigation you can get. But the second fundamental disagreement is this notion that by joining a conspiracy, and you assume that that's true, assuming the facts are well pled, that you somehow are not on notice that you might get hauled into a Florida court if you get caught. And that's my argument, is that he can prove at some point down the line that they weren't involved or they didn't know, and if that's the case, then he'll win his case. But if you join, if you're a bank, you're an institutional lender and borrower who takes substantial fees on what turns out to be a $140 million failed real estate deal where $30 million of people's money was taken, and instead of building condos for these people, we're going to make believe Lake Austin, this is their money for collateral, and then we're going to give them $140 million to build Grand Palisades that never gets built, then somehow, if I know about all this, I have all kinds of requirements in the regulations to do due diligence, to investigate all these things before I get involved in a participation agreement. But if I wash my hands of it and say I don't want to know about it, or if I just simply argue I didn't know about it, then I can avoid jurisdiction in Florida, and I believe that that's improper. Again, I believe that we have sufficiently pled enough facts against Peoples and Dan Moser to bring them into this case instead of the alternative, which is to go up to Indiana and sue them individually and to have two court cases going at the same time, which is the outcome. And I understand that if there is no jurisdiction in Florida over these people, that regardless of that outcome, we can't sue them in Florida. But I believe under the facts as pled and under the case law that clearly they should be involved in this litigation in Florida.
All right, thank you for your arguments, counsel.